So I'm going to get into the first question, which was asked by Musa Wenkosi. And this is a question that Musa asked a while back. So Musa, really apologize for not answering your question when you asked it. It's just been, like I said, jam-packed. But let's get straight into this. So Musa actually asked a very interesting question, and it's about the restructuring of a property portfolio. He says he wants to know, how can I set up a trust structure so that my life cover and car insurance all come out before tax? That's the first part. And the second part is, I would like to know the disadvantages of buying my next rental property through a trust or through a company. Would funding institutions consider my personal affordability as collateral, even though the trust and the company would have nothing in them yet? So I think let's quickly go to Bruno on this one. Bruno?
Sure. So I think we should maybe break down the question into three pieces. So the first question is about utilization of vehicles, to try and obtain some sort of tax benefit, and not typically what you'd, for example, the conversation that we have about buying the property, putting it in a trust or a company, and why we do that. So now we're looking at almost ancillary expenses. So it's very well known that through companies running commercial entities, you can deduct certain expenses from it. So that's definitely one of the benefits that you could be looking at. So for example, in a company, if a person were to have a vehicle that belongs to the company or some sort of insurance policy for that business, you could run the payment, the actual premiums of the insurance policy through that business, right? So that's something that we all do on a daily basis. Like in my firm, for example, there's a couple of insurance policies we have for printers and computers and things like that. So those are expenses against the business, and you'd run it and you basically just deduct it from your income. So if that's the type of answer the viewer is looking at, that deals with certain expenses. Now, life insurance policies do not function like that. Life insurance policy, and this happens a lot, especially with home loans. When a person gets a home loan, sometimes the banks insist that an insurance policy be taken against the life of the owner, because in case something happens to the owner and he passes away, they want sufficient money to be paid out in order for them to be able to collect on any short, basically on the value of the property and settle the bond. Now, what we found with this is when you do submit your tax returns regarding these, like your bank charges for the bond, service fees, even the interest that you pay against the bond, you try to deduct it from any rental income that you get. Insurance policies typically are not included in that. So that's something, unfortunately, the actual premium is not included. If the question is more around the payout of an insurance policy, so the actual receipt of a life insurance payout, that's a completely different tax question though, and what we typically find, especially with trusts, if the payout goes into the trust, SARS will still want the state of the person whose name this life insurance policy is held. They would still consider this life insurance policy to be within this estate. Certain charges might be excluded, for example, your executor's fees, but typically speaking, from a SARS perspective, they'd still want to collect on their estate duty. So to answer the viewer's question in short, run your commercial expenses through these businesses. Even a trust can be run like a business. You can deduct it from income that comes in. These have to be business expenses used in the course of trade for the purpose of making money. So effectively, you'd be using it in order to get this rental income. Again, insurance premiums for cars, because obviously this car is being utilized to drive around from property to property in order to do inspections and things like that. There's a justification. But remember, with SARS, there has to be a justification. You need to be able to show that it is legitimately an expense related to that trade. And so that deals with question number one. Solna, I don't know if you want to add to the insurance part and the expense part.
No, please, no.
Okay, then question number two is whether it's best to buy a property in a company or a trust. This ties in slightly to question number 3 regarding affordability. So I very often have these conversations. So there's a couple of things that you want to look at, 3 basic principles that you want to look at when you're dealing with structuring. And that's typically your asset protection, your tax efficiency, and your financing optimization, right? So you need to try and cater for the 3 of these as best as possible, obviously weighted to your personal circumstances. So there are a couple of things, a couple of reasons why, the few reasons, but there are a couple of reasons why a person might want to buy in a trust directly. There's reasons why a person might want to buy in a company directly. Predominantly, it has to do with the asset protection perspective of it, as well as the tax efficiency. But just to try to cover it very briefly, from an asset protection perspective, you typically need to have a trust involved. So that's kind of like the underlying principle. Why? Because if you own shares in a company, you still own the shares in the company, meaning that those shares fall within your estate. If shares fall within your estate, 2 things happen. Your asset protection is bad because now anyone can attach those shares, and your tax efficiency is bad because when you pass away, SARS will consider those shares in calculating transfer duty, right? So you would typically never want to buy the property in a company just like that you simply own. So the underlying vehicle of a trust is where we kind of insert this protection where we say a trust does not belong to anyone. When you actually take an asset, you give it away to a trust. It no longer belongs to you, which means that the trust is a person on its own. And because it acts like a person on its own, it's not necessarily associated to your estate. Now, there are exceptions to this, and we don't have time to go into this because it's a long conversation, but there are anti-avoidance provisions that SARS likes. There's the alter ego principles that apply a lot when it comes to divorces. Let's assume for a second you're running a legitimate trust and you put all your things in the trust and you've got a bunch of beneficiaries and everyone's benefiting and it's a happy trust. The nice thing with that is whatever's in the trust, whether it's the property directly or the shares of a company that owns the property, bottom line is it's safe. It's away from your estate. No one can attach it. And the trust needs to be properly structured because it needs to be a discretionary trust. Again, long conversation that we don't have time for at the moment. But if you have a legitimate trust that's properly structured, it's separated from your estate, which saves you on transfer estate duty and gives you the asset protection needed. So to ask the question whether you should buy in a company or a trust is not really, there is no right answer to that. It's more a question of, once you establish a trust, if you find that asset protection is very important, that your long-term tax efficiency is important, then I would say you'd probably want to at least consider having the trust. After that point, whether you buy in the trust or the company owned by the trust is completely up to the individual and their specific tax requirements. There are a couple of benefits, not that many, but there's limited benefits to having certain things in the trust directly. But what you find from aspiring investors, especially in the property communities, you want to start building up your track record in the company. And you start putting things in the company, building up the track record. So eventually, after a couple of years, when you go to the bank, you can show your financial statements and the bank's excited to do business with a business that can carry its own. So I typically like the company from that perspective. Also, depending on the tax circumstances, a company does land up being cheaper tax-wise. But again, specific circumstances would dictate whether the trust would be cheaper or the company. But 70% of the time, you'd find that the company would be cheaper than a trust because a trust is a 45% tax rate as opposed to a company at 28%. Again, there's exceptions to that. From a financing perspective, signing as a surety would apply in both instances. So the banks, whether there's any assets in the business or not, up to a couple of years, the banks will not want to consider the company as like almost as a going concern that they'll consider by itself. They will still want the directors or the trustees to sign a surety in order to give them security for that specific transaction. So whether the company has 0 assets or a couple of assets may help regarding affordability, but it will be a couple of years before the bank won't want someone to sign as a surety. So it is a question of affordability. So yes, 0 assets, the loan will still be granted to the company or trust, but then your personal affordability to sign as a suretyship needs to be attractive or appealing to the bank.
Sure.
That was impressive.
Breathe, Bruno, breathe. That was a lot.
That was
advice.
Sure, so
amazing.
we've got time limits.
I give this one a 5-star rating. That was amazing. I can't even add anything other than that was impressive. I share your sentiment.
Thank you.
I concur.
Thank you.
Thanks for that, Bruno. Thank you. Let's move on quickly, swiftly to the next question. This is also a rollover from last week. So we did promise Ricky Khan that we were going to deal with his question and tackle it tonight, and we shall. This question is, can a lease agreement void fair wear and tear of furniture? If it says the tenant is responsible for replacing or fixing any item that breaks. The second part of the question is, what is considered fair wear and tear on furniture? I mean, working from home has increased the wear on furniture. For example, the chair that we're all sitting on right now has probably been worn beyond belief because of the time we spend on it. And he wants to know if something breaks from normal use, albeit more frequent use, is this considered fair wear and tear? Solna, can you please help Ricky with this one?
Yes, I love this one. I just want to state that I stole this chair out of my one boardroom just before lockdown last year. And luckily, I haven't had enough people in my boardrooms since, like we haven't filled them, obviously. Yeah, COVID. So this chair is definitely worn. Thank you, SSLR, for allowing me to really use this chair, because I think I've spent quite a few hours on it. But okay, so let's get to the question. Well, the answer. Fair wear and tear on furniture. When you rent a furnished property, the furniture forms part of the transaction, but it doesn't necessarily form part of the property. Because remember, your stuff, last night I did a webinar for private property, and one of the questions we didn't get to actually was, what is the effect of hier gaat verkoop on a furnished unit? Does the furniture then, and a quick answer to that is yes, because that is a possessory claim that the tenant had. So remember, because the property that the tenant is renting is immovable property, but now it depends on the lease agreement, how the furniture fits in. If the lease agreement is silent on the furniture, so there's no reference made to furniture, unfortunately, the tenant is in a very unfortunate position, because the argument would then be the tenant simply had possession of these items, and the possession of the items can be terminated at any time during the subsistence of the lease agreement by the landlord, because the landlord can say, okay, cool, your lease agreement says you're renting this property from this date to this date, but it does say you're renting the furniture. So at any time, the landlord can say, okay, you know what, lekker, we had like a month to month tacit, whatever verbal agreement, whatever the case might be with regards to the furniture, but I want it back now, and he can end that. So what I recommend definitely is, when you have a furnished lease, have a proper full inventory, because then you pull the movable property, the chair, the table, the whatever, into the lease agreement. And the term of the lease agreement is also the term of the lease of the movable property in the immovable property. And fair wear and tear, like I just said, so keep that, distinguish every time on a lease agreement that makes reference to it, ideally has an inventory of the furniture, and a lease agreement that's silent on the matter. So let's only talk about matters where the lease agreement actually says this is a furnished unit. I know there are furniture in the property, whether there's an inventory or not. Fully furnished unit, you expect a certain, some basic furniture will be in a fully furnished unit, okay? So like I said, inventory or not, furniture now forms part of a lease agreement. Ideally, if you use a proper, well-drafted lease agreement, I would like to see a definition of fair wear and tear in your lease agreement, because fair wear and tear isn't defined in any legislation. It's a term used in legislation. It's a term used in the Rental Housing Act. So for fun fact, the Act, as well as the regulations, use the term fair wear and tear, but then regulation 62M, if I'm right, I'm going to be super impressed with myself. 62M, or yeah, there is that one, says natural causes. So it's something that broke not due to natural causes. Instead of fair wear and tear, it is weird, but it's because the term is not defined. So in a lease agreement, I would like to see the term defined. In the TPN leaseback lease, it is defined, obviously, because, you know, I know somebody who drafted. And it's defined as any decline which results from ordinary use and exposure over time, including breakage or malfunction due to age or deteriorated condition, but not where such decline results from negligence, carelessness, accidents, or abuse by the tenant or the tenant's visitors. That's how I define fair wear and tear. I am quite comfortable with that definition because that wasn't just pulled from somewhere. That is how we see it being referred to in case law and things like that. So I'm quite comfortable that that definition could be used further than just this particular lease agreement. If your lease agreement doesn't define it, remember, a term like that, fair wear and tear, is actually a well-established term in our law. Fair wear and tear is defined as exactly that. Stuff that breaks after time, stuff that's not pretty anymore after time. Oh, like people. I'm lying. Stuff deteriorates and it's not the same condition as it used to be. So it's a very important thing to consider when it comes to furniture, because furniture, normal use of a chair, it will break after a while. The viliki will come loose, or you know, the seam will come loose. Something will happen after a while. If you consider typical wear on an item, that will remain landlord's responsibility. But to the viewer's question, can you exclude fair wear and tear in terms of your lease agreement? No, you cannot. Why? Because the Rental Housing Act, as well as the regulations to the Rental Housing Act, places this obligation of maintaining fair wear and tear exclusively on the landlord, and you cannot contract out of legislation. However, the Rental Housing Act doesn't say anything about furnished units. So the furniture and the damage to furniture, even fair wear and tear, can, in terms of a lease agreement, be placed on a tenant. So you can say, you know what, you can rent this place, but when I get it back, I want it back with the exact same items. If something breaks or gets damaged in the meantime, you need to replace it to the same standard, not better. So you can't rent out a place with a dining room set that's like from, it was inherited from Tani Sunny way back when, and it was already sort of worn, and then expect a brand new amazing thing back. So you can contract around it, but I would rather recommend that you stick to a proper full inventory with a recordal of the condition, ideally photos of these items. I'm sorry, that was a particularly long answer for a relatively easy question. I'm sorry.
But that's great, Sona. I mean, like, getting more than we bargained for you. I also wanted to find out something from you. Does fair wear and tear also apply to relationships? Because my girlfriend is complaining that I just don't do the same things I used to when she met me. So can I rely on that and say it's fair wear and tear?
You can, and it's exactly what I said about aging. Like, if my boyfriend now suddenly says he's going to come and take the network cable out because there's a few extra wear and tear wrinkles, I'm just going to smile politely and say, that's landlord's responsibility. Who's the owner here?
Oh, guys, thank you, Selda. Let's quickly move on to a question by Kathleen Liebenberg. And Kathleen asks, she says, after 12 months of squatting in my house, and not paying utilities or rent in a gated community, we have finally obtained a court date, which is for the 23rd of June, and that being for an eviction order to be granted. She says, if the order is granted, how soon must the tenant vacate the property? Bruno, can we help Kathleen on this?
So unfortunately, it's not really going to be up to her. Granted, if her representatives made the correct submissions in the papers or in court when the matter is going to be heard, you can persuade a magistrate or a judge, wherever this might be, to consider the time periods. But it is in the discretion of the court, and the reason for this is because the legislation in South Africa regarding rental eviction, especially in residential units, do give the courts quite a wide discretion to make certain considerations, especially when people, for example, say that they will be rendered homeless. You may find that a magistrate affords them a bit of extra time in order to acquire alternative accommodation. What we typically find, it's a rule of thumb, but obviously it comes with many exceptions. But what you typically find is the more affluent the area you're doing the eviction in, the shorter the time periods. So for example, affluent areas in northern suburbs of Joburg, you'll find that the only times that orders might not be granted over, or at least the actual dates of eviction, will typically not happen over December because of the Christmas period and the holidays and things like that. So if you're heading to court very close to December, you might face a bit of a problem no matter what area you're in. And as the areas become less affluent, you typically do tend to find that people struggle to find alternative accommodation because it's something that might be beyond their means. So if you're staying in a house with rental worth 20,000 Rand, a court is not going to expect or give you time to go find another place worth 20,000 Rand, or give you expect you to live in those means. So there's a level of reasonableness that comes to it. So if a person in those areas that has a very high value property, you will find that the courts will consider that they can move anywhere beneath those means in order to be able to find a place to live. Whereas, for example, if you go into some of the CBDs, it's a different story, because there's very few places that are a lesser rent. And in those places, you do tend to find that people sometimes struggle, and they might need the court's assistance. And in that instance, the time period, the court may grant them a little bit longer to find another place to stay.
Can I add a few numbers at the risk of causing absolute chaos? Typically, Bruno, and you can say, oh, no, Silma, you're absolute crazy. Typically, a residential eviction where the person isn't going to be rendered homeless or destitute. You won't easily get the court to give an order that they have to vacate immediately on court
Absolutely.
order. Yeah. The court typically gives a month and allows you to send the sheriff after a month. However, I have seen evictions, to your point, Bruno, where the court gives three months in a exactly where the tenant might have a problem. But I have seen evictions. Luckily, I haven't seen it in SSLR, but I mean, we've seen case law where the court orders up to 6 months before we can send the sheriff to attend to the eviction. I've never had an order like that, but I think the longest time period we've had was about 4 months. But I know there are longer ones. So unfortunately for this viewer, I know it's right there, and it's around the corner, the 23rd of June. It's actually one of my paralegals' due dates for a baby. So that it might be a good sign. It's a good day. So it doesn't necessarily, unfortunately, mean that you're gonna get the order, and you usually can't blame your attorney for it. We are all doing our best, but we are struggling. Things are a little tough around court orders right now.
Yeah, I absolutely agree. Look, the best I've received recently, but this was because of a number of postponements. I think the magistrate just got tired and gave 2 weeks, and we haven't seen 2 weeks in ages. It was actually quite a surprise where it was like, oh, get out in 2 weeks. It almost took us longer. I think we actually spoke about this last week. It took us longer to get the order from the court, because as soon as it was given, we had to go find the court file, try print the order. Then the court file was missing. We had to take a transcription. It took us 2 weeks just to get the order printed, and now we're executing immediately. But that's the best anyone could possibly expect, and it's very, very, very seldom. To Silna's point, 1 month. 1 month is the appropriate time frame from what we've seen.
Sure. Thank you, Bruno. Thank you, Silna. I know Kathleen actually would be thanking you guys as well for that information.
I don't know if she would, because it's not a joyful answer.
But it does give her a little bit of clarity in terms of what she can expect. So I think, yeah, sorry, Kathleen, but yeah, there'll be a little bit of waiting. Hopefully not. Let's move on quickly to the next one, which is a question by Brigitta Schultz. And she asks, if a homeowners association has 0 common property and is an open estate because the municipality won't allow the streets to be closed, is there a way to get rid of this homeowners association, since the only expense of this homeowners association is the management of the levies? She says the homeowners association is registered with the municipality as well as with CSOS. Silna, can we give Brigitta some hope? Yeah.
Oh, she's so yes. I must say, I can see what happened here. There was a bunch of owners. They were like, "Yay, we want a gated community. It's going to be amazing. We're going to have like street braais," and then they registered the company. They did the MOI for the homeowners association. Everybody was in there. They probably had a braai to celebrate this, and then they went to the municipality and said, "Listen, look at what we're going to do." And then municipality said, "No, you're not putting up a gate." And then effectively the whole purpose for all of this fell away, but now it was already in place. Depending on the way it was structured, depending on the Memorandum of Incorporation, because remember, a homeowners association is formed in a company structure. So your Memorandum of Incorporation must deal with, can somebody translate ontbinding for me quickly? The end and winding up of the company, winding up. I can't believe I just asked you guys for Afrikaans translation on binding for winding up of the company. So the end of the company, how does it work? How is your shares, how will your shares be paid out and things like that will be dealt with in your MOI. In this case, there's obviously no value in the shares there, so that shouldn't be an issue. But you would be able to do that, but unfortunately it will be on a vote, typically, like I said, depending on the MOI, but a vote from the shareholders and then potentially the directors of the particular homeowners association. So that could be a tricky thing, because if there's somebody with a bit of a high need or want for this, because there might be future benefit in it, there could be a problem to wrap it up. So my recommendation would be get into the reasons why this is the only thing that the homeowners association is doing. I would get behind what was the initial plan, why is it backfiring, why is this not a solution for right now, can we wind it up or not, and if you can do it in terms of the MOI.
Yeah, absolutely. That's perfect. Absolutely agree with that. The company has a purpose. And I mean, this is just your normal company. Law company has a purpose. If it cannot achieve its purpose, you can actually even go to court to try get it wound up on the basis that it hasn't. It does really depend how far everyone's gone with this. So, I mean, have we gone, to amend title deeds, or is this just literally a company between people where they've made certain contributions or certain promises? Because in that case, it is a contractual issue, and it's something that can be decided if, again, the purpose hasn't been achieved. What is actually quite unfortunate is there's better schemes for things like this. So I can't remember the name of this. I did a research on this a couple of years ago, but it's something along the line of a community development scheme or something. And basically this is, so again, certain goals are being sought. So people, for example, want to get their own trash people to put the trash together, or want to put it only in one place in this community. They want to block off the roads, and they want to contribute levies in order to be able to afford these like security guards and security companies and the like. And you don't actually need a HOA for this. There is a structure where you guys can reach this agreement and still apply to the municipality to achieve this goal. The HOA, the reason people do HOAs isn't just to close off the community, it's more lifestyle. It's, if you look at HOAs, typically it's security, closing off lifestyle, common areas, parks for kids, a golf course, like something special. Closing off roads, if that's the only purpose, then a HOA might be a bit overkill for that. And yeah, if you guys do want to start over, I would suggest get rid of the HOA and start again with this community scheme, which I can't for the life of me remember what it's called, but it exists. Most of the closed off places have reached some form of agreement like that.
Oh, thanks, Bruno. Thank you, Solna. And that brings us to the end of today's session. I just want to apologize firstly to those of you who have asked questions and we've not had the opportunity to get to them. As you can see, we did have a jam-packed session and a lot of questions that had rolled over from previous weeks, but we definitely will get through to your questions. And I think another great thing is that we have a lot of legal professionals, both junior and senior, who watch us. And it's so good to have you with us as well as we take this journey. But I just wanted to say that if you guys have any questions, legal professionals, or the general viewers, please feel free to contact Solna at SSLR Attorneys and Bruno at Bruno Simao Attorneys. I know that they're always willing to take on, these questions that you guys have, and we'll provide the solutions to you. So thank you so much, everybody, for tuning in. Please drop your questions and comments for next week's episode in the group and in the comment section. And yeah, we're looking forward to seeing you all next week, Wednesday at 6 o'clock. Solna, goodbye. Bruno, cheers.
Bye-bye.
Cheers. Thanks everyone.
Bye-bye.